The letter arrived on a Tuesday, plain envelope, HOA letterhead, and a number that made my hands go cold. $347,500. That was the total they claimed I owed. Fines stacked on fines, violation upon violation, going back nearly 3 years. They gave me 30 days to pay or face a lien on my property. 30 days. A third of $1 million. What they didn't know, what nobody on that board had apparently bothered to find out, was that before I ever put a single post in the ground, I'd done something they never expected. I hired a land surveyor, and what that surveyor found was going to change everything. Not just for me, for every single house on Crestwood Drive. The CC&Rs were 14 pages. Standard stuff. I signed, I closed, I moved in. 6 weeks after the fence was completed, I found a violation notice on my door. Went home, I pulled out a tape measure, and I measured my fence. It was exactly 6 feet tall on every panel. Diane looked at me over her glasses and said, "The board's interpretation of the CC&Rs supersedes homeowner documentation." Over the next 8 months, I received 11 more violation notices. I hired a real estate attorney named Marcus. He reviewed my file, all 73 pages of it. They're not just aggressive, they're sloppy. Aggressive and sloppy is the best combination you can face. Marcus, going through the county recorder's office as part of his case prep, had found something odd. The amendment was drafted. It was signed by the developer, but it was never recorded with the county. That parcel, Parcel 7C, had never been formally conveyed. It was still titled in the name of the original development company. That development company had dissolved in 1993. The entrance pillars, the landscape median, the retention pond, the mailbox kiosk, all of that was built on a parcel of land that was never legally transferred. My property, my corner lot, was directly adjacent to Parcel 7C, and I was the only adjacent property owner who had a recorded survey touching that parcel's legal boundary. It took 14 months, a quiet title action, a title search, notice filings, a hearing before a county judge. On a Thursday morning in November, a judge signed the order. Parcel 7C, 1.3 acres, was transferred by quiet title to my name. The HOA had been maintaining, landscaping, and making improvements to Parcel 7C for over 40 years without legal authority to do so. As the owner, I had the right to determine access. I was not at this time blocking access. I was at this time formally revoking the HOA's assumed easement. If the HOA wished to purchase Parcel 7C from me, I was open to that conversation. The opening price was $415,000. We settled 4 months later. The HOA purchased Parcel 7C for $275,000. All fines against me were formally vacated. The fence is still standing, 6 feet tall, stain color exactly as approved.